can the intention of the Parliament as it existed in 20 be supplemented or amended that this was the intention?
That you can always do. That there is no, Parliament's power is untrammeled.
Let that be argued. My lord, they were not comfortable in arguing this point. They said, let it go to the regular bench. I am ready to argue. This is set aside by the division bench of a High Court by a reasoned order. I am ready to
Parliament
support.
does that all the time in the case of fiscal enactments. You'll have amendments by the galore in the Income Tax Act. The moment a judgment comes, they will amend it with retrospective effect.
My lord, my lord, there are, we have, my lord, judgments on.
So what we call a validating statute or.
My lord, we have judgments, my lord, whether this can be done or cannot be done, and to support the judgment of the division bench of the High Court, and we have filed an
But then one thing, let's have conceptual clarity on what we are going to write on. I mean, what is the canvas on which we are going to write? If they are not arguing on the.
They are not ready to argue.
No,
We
ready to
want
argue.
them to argue.
They are not arguing. That's their choice. 1 second.
We shouldn't argue the 81 Act.
No, they said that let it go to the regular bench. They say.
1 second. We've got our notes. In the opening, they have said that they are not arguing on the validity of the 81 amendment, which forms the subject matter of the Allahabad judgment. So, for the purpose of this reference, then, do we proceed on the basis that the 81 amendment is a valid amendment?
It cannot be.
The 18 or 81, the other way around. Amendment is now effaced from the statute.
Yes, but it's not. It does not exist on the
By this court.
It's not stayed. It's not stayed. The court said status quo because they have granted reservation.
One second.
That was the state. Therefore, say that the
Where
status quo.
reservation, it is not state, otherwise it's status quo ante.
No, I'll show the
The
order.
order of the court. It's there. It is status quo ante.
No, you have-
Other than the
You
issue.
can't have it both. Let us be very clear.
If I remember correctly, what had transpired was, we were, that in case it's a minority institution, then the corrector will be issued in terms of the Constitution and the rights protected under Article 30. So we are going on that basis.
All
To say to the solicitor, the argument of which has been raised is that in Badshah, the court found three things. One, it was legally established. Two, in fact, de facto also, it was established not by the state. It was established by the state and not by the minority institution. And third, it is not administered by the minority.
And four, you have whatever rights you had, you have surrendered those rights.
So that's part of the second, that it was not established and administered. It's a part of second and third itself because you surrendered.
So
those.
that factual finding that you have surrendered.
So your argument is even by adding even by deleting the word established from the statutory enactment, it will not unwind or rewrite the judgment of the Badshah's case that it was de facto established by the state. What is relevant perhaps is that prior to in the original enactment, the successors to the Chancellor shall be elected by the court.
No.
And number two, Vice Chancellor also, the successors to the first Vice Chancellor shall be elected by the court amongst its members.
Yes, ma'am.
After the amendment, they will be appointed by the visitor.
By the visit.
But such appointment shall be subject to the approval of Governor General in Council. Vice Chancellor.
One very interesting amendment which was made in 1972, come back to section 5.
Yes.
See 5(2).
Yes.
University shall have the following power. 5(2) was to promote Oriental and Islamic studies and give instruction in Muslim theology and religion and to impart moral and physical training.
This was original.
B now comes in.
Yes.
It says to promote the study of religion, civilization and culture of India.
Of India, not one religion.
It becomes more secular in its
More
form.
secular.
And then comes
thereafter-
81. And then comes 81.
Yes, Manoj, please
81
come to
is green,
81.
right?
Manoj.
Green is 81.
Lord, definition clause. Please come to the definition clause. This does not stand as of now, Malord. It's set aside. L, Malord. 2L.
University.
Yes, university means Aligarh
Just one.
Lordship C. L.
Yeah.
University means Lord, originally it was Aligarh Muslim University, the educational institution of their choice, established by the Muslims of India, which originated as the Mohammedan Anglo-Oriental College, Aligarh, and which was subsequently incorporated as the Aligarh Muslim University.
What the amendment of 1981 did was to squarely sort of give it a minority status. That was the object. Because two things they did. They deleted the word established from the preamble, and in the definition of university, they now take it, it's a recognition that, well, this was established by the Muslims of
Whether
India.
that can be done or cannot be done is a subject.
No, that's a separate issue.
That's a separate. That's what they did.
What
Yes.
was the purport of the amendment?
Yes, bro. That's what they did.
Solicitor, it's well settled that the legislature, whether it's a state legislature or parliament, can take away the basis of an act of the basis of a judgment. So, for instance, if a judgment holds a statutory provision to be violative of Article 14 on the ground that it does not comport with natural justice, the legislature can introduce a provision for natural justice so as to make it in conformity with the law by supplanting the deficiency which was noticed by the judgment. So what you can't do is to directly override a judgment, right? So, for instance, the classical case was Madan Mohan Pathak, where there was a binding settlement, an industrial settlement, on which a mandamus was issued by the Supreme Court. That settlement was sought to be overridden by an amending provision, which the court held this you can't do because it has attained finality. Now, what does 2L do? 2L, or before we go to 2L, what did Basha do? Basha said that AMU was not established by a Muslim minority, but was established under an act of the imperial legislature, right? And it is administered not by the minority, but is administered by this institution, by the act. Can by merely an amendment to the definition, can you take away the basis of Basha? Because
Lord, my legal
2L does, possibly what the argument, and this we may have to hear the other side in response because this was not argued in the opening, that 2L merely alters the definition of the expression university. But does the alteration of the definition of the expression university take away the basis of Basha? That the very establishment, now what the 81 amendment does is, it doesn't purport to establish the university at all. Now, it says that the word establish is taken away from the preamble.
but incorporated remains.
Incorporated remain. Then 2L says that it was established by the by the Indian Muslims of India, originating as the MAO College Aligarh,
Correct.
and which was subsequently incorporated.
The argument rejected is in Basha is incorporated by way of a definition.
Now, is this amendment, by the way, in 81, is it retrospective or is it prospective?
Lord,
Lord, our argument before the Allahabad High Court is it's declaratory in nature and therefore retrospective.
Necessarily retrospective.
That was the argument.
Lord, I don't wish to give examples, but if you can change history by changing definition in a statute, your lordships can, with your lordships' wide experience and wisdom, visualize, Lord, what can be done. There are several historical facts, my Lord.
No, Parliament
which
can do it.
May, my Lord,
But
Parliament
no,
think of
Parliament
change.
has the power to do it. Parliament has the power to do it. Because Parliament can, while implementing a statute, subject to a challenge under Article 14, Parliament can...
Competence, yes.
It has the competence to say this
But
is our
whether
view
it
when we enact
amounts
the law.
to effacing
Again,
Basha or not, that's a question.
That the more important substantive point is this really declaratory as they are arguing? Or are you merely amending the definition without taking away the basis of Basha? The latter you cannot do. The former you can do.
You can't sit in appeal. The Parliament cannot sit in appeal and set aside the judgment. It can, if there is some lacuna found by the court, that lacuna can be filled up. But, Lord, it is my submission and
Basha said that AMU was not established. Basha says AMU was not established by the Muslim minority,
intra-party dispute
but
is
it was established under an act of the imperial legislature. Thus, this can merely an amendment to the definition of the expression university take away that basis of Basha.
And, my Lord, their argument that it was established by the educational institution of their, by Muslims of India, which originated at
Because to take away the basis of Basha, you have to take away the underlying facts on the basis of which Basha has been decided. Have they really altered those underlying facts by this?
I requested your lordships that I would like to read Basha the way I request your lordships to read. Basha doesn't say what they are apprehending. Basha is a sui generis Allahabad, Aligarh University case. And it defines and records certain factual findings also, which, my lord, this amendment of the parliament seeks to do away with.
Is there an alternate reading not possible? I mean, we are discussing various options. I mean, we just because the idea, it's not an easy, it's a thorny issue. The original act said the university is established and incorporated under this act. The preamble says established and incorporated. Right? Suppose established was not there and it had merely used the word and incorporated under this act.
Only incorporated.
In which case, it would have been established by whoever it had been established by, but it was given a statutory form of a juristic personality by the original Act of 1920. Now, Basha relied heavily on the preambulary provision, which says established and incorporate. That is, means you are setting it up for the first time by the Act of Parliament.
Even incorporation would
Is it
be
not
setting
open-
it up for the
Right.
first time.
No, that may be a little different because incorporation is giving it a juristic form. Establishment is an establishment in fact. But is it not, is it open to Parliament? Is it, or put it the other way, is it not open to Parliament to say that, well, Basha relied on a statutory provision, namely the word established, to hold that it was established under an act and not by somebody divorced the statute. We will amend the statute to take away the word established, so as to make it clear that our intent is that this was only given a juristic form by the Act of Parliament.
Can the
Can Parliament
intention
not do
of
that? Can Parliament not do that?
Lord,